And somehow the checking of the box means that you understand and read everything, but really, who reads and understands? You're not smarter because you figured out how to use aforementioned and whereas and supra and notwithstanding. I mean, come on.
Welcome to Gavels Down, Voices Up, where we flip the script on conventional legal discussions. I'm Rachel King, here to guide you through the murky waters of family law, estate conflicts, inheritance disputes, all of the dramas. We're not just talking about law, we're talking about how it affects your life, your rights, your future, and your money. From the courtroom to your living room, we bring you insights that matter. Dive into each episode ready to challenge, learn, and grow. Ready to change the dialogue? Let's begin. Gavels down, voices up.
Today it's all about legal documents because is there anything more fascinating? Just kidding. All right, so when I was in law school, I was in a contracts class because I thought that would be a fun elective to take. And I quickly learned that I can't stand reading legal documents, and I'm an attorney. Now, of course, I've gotten better at it. I've learned to appreciate the value of a well-written legal document, but still kind of a snore fest. And again, I do this for a living, and I'm trained in how to handle them and how to digest and wrap my head around everything that's in it. So if you're not an attorney, what a mess. Today, we're going to talk a little bit about legal document drafting and some ways to make it better. We're even going to get into the fine print. You know, all that boilerplate language that's in the massive documents you get in the mail after you get a credit card, or when you're buying something and you have to scroll like a mad person to get to the bottom of the terms and conditions and check that box. And somehow the checking of the box means that you understand and read everything, but really, who reads and understands any of it? Yeah, we'll talk about the fine print too. So, when you're talking about a legal document, there's a real fine line between being overly inclusive and just so hugely detailed and really getting a point across so that it's understandable. And where is that fine line? How does it play out in court? Today, we're going to talk about what I do and how I handle legal document drafting in my professional life, but also in my personal life. First, let's start with maybe something that's a bit obvious, but can never be said too much. Sure, verbal agreements, they are mostly enforceable, unless we're talking about a will or something, and that's a whole separate legal document. But for the most part, you can contract verbally. There's limitations to that, but even if you can, it doesn't mean you should. A verbal contract that goes south is very likely to result in a he said, she said battle in the courtroom where everybody's trying to come up with outside corroborating evidence to show and prove that what they are saying actually happened. And in every single one of those cases, there's an attorney behind the scenes, a judge sitting behind a bench, or a party saying, oh God, we should have just written it down. Yeah, you should just write it down. And you shouldn't be afraid of contracts and legal documents. In fact, when everybody's getting along, when things are well, that's the best time to do a legal document. Why? Because there's no conflict. And trying to handle an agreement or what should have happened when there's conflict is a nightmare. Sure, it's my living and it puts food on my table, but I mean, you're not here for that. You're here to protect your own stuff, right? Not pay for my cheese. So let's talk about legal document drafting. We've all read a document or heard maybe on television or in a movie some legal language that is so out there. You're like, what in the actual world did I just read or hear? I remember when I was in law school and I was reading all of these case opinions and so many legal documents, and it was like, aforementioned, herefore art thou, supra, notwithstanding, whereas. I mean, all of these terms, and it's like, what are you talking about? Why do I have to learn a whole new set of these fancy languages to understand what this darn document says? When I was also going through law school, there was the beginning of the movement of plain language in law. I'm pretty sure this is still a movement. I'm also quite certain that just like it was when I was going into law school and now, there's a lot of people that fight against it. Even current attorneys, not just older attorneys, always seem to want to use these ridiculous words. And I just don't understand why. Like, you're not smarter because you figured out how to use aforementioned and whereas and supra and notwithstanding. And I mean, come on. There are some of them that I like. I was always really fond of moreover. Anyway, I digress. Plain language in law. The day that I had a professor tell me that there was a real push to get out of the legalese and into plain language, it was like the clouds split apart and I finally figured it out. And I thought, goodness gracious, I'm just going to write legal documents so that they make sense. It doesn't make me any smarter to use fancy words. And in fact, maybe it will make me a better attorney if I just write things in a way that the everyday person can understand. And I've really tried to do that in all of my legal writing. And what I would tell you is that it's okay for you to do that too. It's okay if you're writing a contract or a legal document to just use the words that you would normally speak. Plain language is fine. And plain language is easier to interpret, I think, than any kind of legalese down the road. If you simply write what you intend, it is far easier to prove and for a judge to understand or a jury to get what was supposed to happen. It's also probably easier for you to write in the event that you don't want to hire an attorney to write out every single thing. So, my number one tip for legal document drafting is use plain language. It's okay, and it's preferred. My next tip when you're document drafting, and this is again, if you're using your own document, you're writing your own document, or you're reviewing a document that's being drafted for you. Plain language. Make it plain language. If you didn't write it, turn it into plain language. You can strike whereas, I think, in almost every single contract. Just get rid of it and start with whatever it is you are trying to say. Whereas the parties agreed that husband was going to pay wife, whereas the parties agreed that the car would be sold as is. Just get rid of it. The car is being sold as is. Husband is going to pay wife, whatever it is. You can get rid of whereas almost all the time. So get rid of the fancy language, keep it plain language, strike legalese. It's nonsense. And this is coming from an attorney. Two, put in all the material terms. Now, what is material term? It's a fancy legal term of art, but I'm basically going to say if it was important enough to negotiate or to be considered, or it's a deal breaker in the contract, it's probably a material term. If you getting paid $500,000 for your house is one of the only reasons you decided to sell your house to this particular buyer, and you wouldn't sell it for $1, then that $500,000 mark is a pretty important term. If you're going to pay Sally $10 because she brought you orange juice, but you're not going to pay Joe because he didn't bring you anything, Sally is probably a pretty important term because that's who you're going to pay. Include all of the material terms. That's again a term that you negotiate, a term that was important, a term that you thought about, or a deal breaker. I just wouldn't even enter this contract if it wasn't part of the agreement. And here's why. Because if it all goes to hell, you're going to want to enforce those terms. And so you need them written down. Everybody's getting along when you're drafting this document and you're writing it in a way that everybody can understand. So it's not like you're trying to hide something. So just put it down. Write it as you are thinking you're agreeing to. The idea behind any contract or legal document is that you're writing down what you want in a way that the other people understand what you want. Get rid of all the judges and attorneys. It's just two people. I want this, you want this. Great. I'm going to put down what I want. You're going to say what you want. We're both going to sign that we understand. Keep it simple, but include the material terms. Third, proofread. Proofread your own documents, proofread documents that other people wrote. If it is going to be a document that has any legal weight, even if it's a napkin will or a quick word bill of sale, proofread it. Make sure that your commas are in the right spot, that your language is there, and that you haven't missed any of the material terms. Read it out loud after you read it in your head. Why read it out loud? Because our brains are so fantastic and so complicated that they know what we want it to say, and they will literally read what we think it says and not what it actually says. So take some time, read it in your head, but then read it out loud and make sure it says what you think it says. And then I'm going to go a step further and say, have somebody else read your document. Sure, they can proofread it for terms and commas and spelling and all of that. And that's nice too, because if you're going to have a legal document, it's really great to have the commas and the punctuation be in the right spot. But more important for this other person is without any information from you, you want them to give you all of the who, what, where, why, when, and how. Remember that stuff we learned in grade school? Give them the legal document and say, can you just say who this involves, what it is, where it's supposed to happen, when it's supposed to happen, why it's supposed to happen, and then how. How is this all going to come together? Let them tell you what they think your legal document does. And then if they explain it all wrong, you know that it's not written clearly. Maybe it has some legal language that should be clarified. Maybe it's missing a term or something that you thought was really important. So have somebody else give you all of the W's, O, and that H.
Let's take a quick break. If you're navigating the twists and turns of divorce, you might be wondering, getting divorced, now what? That's actually the title of my upcoming book, designed to guide you through the challenging and emotional process of divorce. It's packed with real life stories, expert tips, and motivational insights to empower you every step of the way. While it's not available just yet, you can join the waitlist to make sure you don't miss out. Head over to rachelkingattorney.com to sign up to be the first to get a copy and enter to win a free signed copy as soon as it releases. Arm yourself with the knowledge to move forward confidently through this challenging time. Now let's get back to the show.
And now let's talk about all of the details versus vague documents. So I think this is a really fine balance. And I say this even as I practice law and prepare for trial. I think overall, this idea of detail versus vague is a balance. If you're too detailed, it can cause problems. It can scare away the other person. It can make actually complying with the agreement more difficult. If you're too vague, it can also make complying with the agreement too difficult. It can prevent any remedies under the contract because it's not really clear. So you want to have just enough. And that's where I say you want the contract to illustrate what you want it to do so that both sides can actually perform. If I'm selling my house to Sally for $500,000, I probably want to know that she's going to pay me $500,000, that I'm going to give her my house, how that money is going to be deposited, how this transaction is going to go down, because that's important. And if it's missing, I don't want her to say, well, it didn't say when I had to pay you the 500,000, so I'm going to pay you in 30 years. No. At the same time, it doesn't necessarily need to be so detailed that I know which account Sally is going to be paying me the $500,000 from. That's really not my business. And then what if we include that, but then she has to spend money and then she has to find it and pull it from somewhere else? Have we just put her in breach because she's not taking the money directly outside? So you want to balance too detailed with too vague. Another time that this comes into play a huge amount is child custody and visitation agreements. Yes, of course, we want an agreement that everybody can comply with. And there's a tendency to want to make it more detailed the more high conflict the other parent is. Visitation is at 5 p.m. We're meeting at the police station. If opposing parent is 5 minutes late, visitation is deemed canceled, blah, 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 right? You want to put all of these things in. But sometimes more details can cause problems. What if parent was stuck at the light, just right turning into the police station, and turned into 6 minutes right as the light was turning green. And you're like, I don't care, 5 minutes. And now we've got an issue of visitation being canceled and contempt of court and all of this, when we could have made the language a little bit more flexible to allow for everyday life, and flexible enough so that everybody can comply with the spirit of the agreement. You really want to balance details with vague. It's hard. And that's where I say you want to look at your contract and say, can I do this? Does this have all of the information I need to be successful under this contract? If not, you might need to add in more details. On the other hand, if it's so detailed that you're feeling overwhelmed, like, I don't know what to do, I know this is too much, it's too much, then maybe take some of them out and go back to just the material terms. And so with that, we'll talk about fine print. Because again, even as an attorney, I will admit I don't read all of the fine print, because honestly, if I want the MasterCard, I'm going to get the MasterCard, even if I don't like everything that the fine print says. And I can't negotiate the fine print. So, I don't know about fine print. I will say boilerplate language, fine print, you should read it. You should understand what it says, because that's the attorney in me telling me you don't ever sign anything or agree to something that you don't fully understand. But the bottom line is the court also sort of understands that most people don't read the fine print. And that's one of the reasons we have huge class action lawsuits against Visa and MasterCard, or whatever the case may be. So don't be afraid of the fine print. You want to keep the fine print. If you're drafting a document, be aware of the fine print. I will say in most of my legal documents, the fine print boilerplate is less, because if it's so important that I need people to know about it, I don't want it to be hidden down at the end. I want it to be in plain sight. And in fact, when I draft documents, the worse the term is for the other side, the bigger I make it. I'll be damned if you say that you didn't know that there was a 25% late fee every day. This is probably illegal, but every day if you didn't pay me back because I hid that little term at the bottom. That's going to be in plain sight, bolded, underlined, centered, huge, all over the page, so that you can't say you didn't know about it. Now, you don't want the whole document to be bolded and underlined, so you're going to pick the fancy terms. But that is one of the things that I do consider when I'm writing, is if it's something that is so important that it may be a deal breaker for them or they're not going to like it, I want it in their face. Sometimes I even add an initial right there. Just, this is so important that I want you to initial that you actually read this. You'll see that on other documents that you sign, right? The bottom line is that if you have a well executed document, it is going to be easier to comply with and less likely to result in a conflict. And to the extent that there is a conflict, you're going to have a really solid document that you can go in and say, hey, they didn't do what they were supposed to do. And it's more likely to result in quick findings of the court, a quick settlement, or just an overall better legal proceeding. Anytime you're looking at legal documents, it is 100% to avoid unanticipated disputes or anticipated disputes. But more than anticipated disputes, you want your documents to address unanticipated disputes to the extent that you can. I would say, in my experience, most of the things that are litigated are the result of unanticipated disputes. We thought everything was going to be fine. Everybody was getting along. This was the agreement. And then 10 years later, it's like it imploded. Nobody saw this coming, and so we're litigating. So as you're preparing and figuring out, do I need a legal document or not? One, remember, it's easier to reach an agreement and have things put in writing when everybody's getting along. And two, the purpose of the legal document is to handle anticipated and unanticipated disputes when they come up in the future. Legal document drafting is an art. That's why attorneys get paid so much money to do so. But not everybody can afford an attorney. And even if it's in a document that you don't have to write, that you're just signing, I'm hopeful that these little tips and tricks will help you read, understand, and potentially write agreements so that you understand them, especially if you can't afford an attorney. I'm here to hear all your stories about that crappy contract that you didn't sign but did agree to that ended up in court. Or maybe you have a story of how successful an agreement was. I'd love to hear it. My name's Rachel King. Until next time, this is Gavels Down, Voices Up.
That wraps up another episode of Gavels Down, Voices Up. If you found value in our discussion today, please subscribe, leave a review, and share with someone who needs these insights. Your engagement helps us grow and impact more lives. I'm Rachel King, thanking you for listening and reminding you to speak up, because every voice deserves to be heard.